I would start by telling you that almost 25 years ago to this very day, the United States Supreme Court decided the Cruzan case, which is the only true right-to-die withdrawal of life support case that the United States Supreme Court has ever decided. We talked about what the court's holding was, I believe, in the first session, and I'm not really going to go over that again today. But what I wanted to put in front of you is some interesting language that appears early in the Cruzan decision, which really implicates much of why we are here today. The court says, as you can see on the slide, that the timing of death, which once was a matter of fate, is now a question of human choice. Nearly every death involves a decision whether to undertake a medical procedure that could prolong the dying process. Such decisions are difficult and personal, the court says, and must be made on the basis of individual values informed by medical realities within a framework governed by the law. What we've tried to do in some of our earlier sessions is talk about the law of end-of-life decision-making, Jewish tradition, Jewish considerations in the end-of-life decision arena, medical realities. Dr. Paletta talked about that last session. So we tried to essentially present much of what the United States Supreme Court is alluding to in this quotation. And where does this lead? Well, as this cartoon shows, a doctor has installed a pacemaker for the patient's heart and says you can also download apps for your liver, kidneys, lungs, and pancreas. And you can imagine, as medical technology evolves more and more, who knows what the next cartoon will be, but certainly medical technology could, if we permit it, drive all of our end-of-life decisions. Now, not everybody feels that that's what should happen. As a matter of fact, most people reject that notion. I can tell you that in my legal practice, I can think of 2 clients in the last 30 years who have said to me that they wanted their medical durable power of attorney, the one I was preparing for them, to say that they desired to have all the medical technology possible made available to them. 2 out of hundreds. And I said, that's your right, and I wrote that right into their document. Most people don't feel that way and want to have some control over their decisions and not leave them to machines. What I've said here, Michelle's chocolate test. Michelle is a lawyer who used to share space in my suite, right across the street from Temple Bethel. She was a friend, a wonderful lawyer, still is, but she doesn't practice with me anymore. Funny, very down to earth, very practical, and she loved chocolate. So we would talk about medical technology and end-of-life decision-making all of the time. And I'm going to tell you about that conversation because she wasn't my client. We were just friends, and I'm free to talk about it. Well, she said to me, you know how I love chocolate. And in fact, if you went into her office, there was chocolate everywhere. Everywhere. If she came to see you in your office, she would bring chocolate. So she had this affinity, maybe an obsession with chocolate. And so she said, well, Andy, you've said that you can really put whatever you want into your advance directive. Could I say the following? I'd like my advance directive to say that if I were ill or injured and in bed, put chocolate by my bedside. And if it's there in 24 hours, pull the plug. I told her she could do that. I doubt she did. But the point is this. Michelle was trying to express for herself what it meant for her to be alive. She wanted to take some of her own values and incorporate them into her document. Again, I don't think she really put that in her document, but knowing Michelle, she might well have. What she was saying is that this is my decision, this is my autonomous decision-making right, and I'm going to express it however I want. Leslie Gore, the pop singer, died a couple of months ago, and in fact, this autonomous notion was carried to the extreme by one author who, taking Leslie Gore's song, "It's My Party and I'll Cry If I Want To," wrote a law review article about physician-assisted suicide, entitled it, "It's My Body and I'll Die If I Want To." This was done, you see, in 1995, right at the time that Dr. Kevorkian was really doing his thing in Michigan. And there were some commentators around the country, including Mr. Friedman, who articulated that people had the right to physician-assisted suicide, that our bodies are our property rights. And this article that he wrote was based upon and recognized what he said as a property right analysis in our bodies. Now, let's bring the issue back to Michigan. In the first session, you remember we talked about the Martin decision, which is the only right-to-die case that made it to the Michigan Supreme Court. And I think I explained to you at that time that I handled that case through the courts, that Michael Martin and his family were driving in a car going out to dinner one evening in January of 1987. Their car stalled on a railroad crossing. It was hit by a Conrail locomotive. One of the girls was killed. Everyone else in the family was catastrophically injured. Michael survived, but was left in a horrific state where he could not perform any basic human function, but he was conscious. And he had told, as I described in our first session, he had told his wife, Mary, if I am ever in a situation where I am helplessly or hopelessly ill or injured with no meaningful hope of recovery, I do not want to be maintained artificially. And he added, if you permit that, I will haunt you till the day you die. So Mary ultimately came to me and we litigated the case. The lower court and the Court of Appeals ruled in Mary's favor that she had the right, as Michael's wife and guardian, to withdraw life support. But we got to the Michigan Supreme Court and the court reversed the Court of Appeals decision, ruled that we could not proceed with withdrawal of life support. What I want to point out to you are two quotes from the Martin decision. You see, this one, which is at the beginning of the case, really is a recognition of our autonomous right, of our right to make decisions for ourselves. We're mindful that the paramount goal of our decision is to honor, respect, and fulfill the decisions of the patient, regardless of whether the patient is currently competent. And in a moment, I'll show how that translates to advanced directives. But the court was saying, we all have the right to speak for ourselves, and that's what the court should do. But by the end of the decision, the court says, well, if you can't show by clear and convincing evidence that a conscious, incapacitated individual had stated before his illness or injury that he did not want to be maintained artificially under the present circumstances, courts won't authorize it. So what were the present circumstances? Michael was conscious but couldn't do a variety of things. Well, he had never described his wishes to his wife in that sort of detail. His description was, as I said a moment ago, Mary, if I'm ever in a helpless and hopeless condition with no meaningful chance of recovery, I do not want to be maintained on life support. Well, remarkably, that was not good enough for the Michigan Supreme Court. The court said we didn't show evidence of his wishes under the present circumstances, therefore Mary, as the wife and guardian of Michael, could not have life support withdrawn. Well, many people were appalled by that decision. The question was, since cases go on for a long time, if we had acted based upon a lower court's decision while the case was still pending on appeal, would there have been liability? The answer is yes. As a matter of fact, after the initial trial court decision, when the other side appealed, it obtained a stay, an injunction that prohibited Mary and the facility where Michael was residing from withdrawing life support. So we would have violated the court's injunction. So one of the things I did after the Martin decision was I wrote a law review article entitled it, Mary, Mary, quite contrary, how was I to know? I was pointing to the fact that Michael was saying to Mary, I couldn't have known my exact circumstances, but I thought I was sufficiently descriptive to cover my current circumstances. But you know, law review articles don't really do anything. They express maybe your intellectual anger, but what that left me to do was to make sure that my clients and anyone who had occasion to listen to me would decide that their solution was to go with advanced directives, to have a document that states their wishes so that no court, whether it's the Michigan Supreme Court or any other court, would say, no, you can't do it. So now we're going to talk for the rest of the day about advanced directives and what should go in them. An advanced directive, as this slide shows, is simply a written statement of a person's wishes regarding treatment. A statement made in advance of the time that person really needs to have them acted on, so that if there's ever a situation where the person can't communicate his or her wishes to a doctor, there they are, they're in writing, they'll be followed. There are two kinds of advanced directives. There's a living will, which is simply a document where you express what you want, and there's the document that we really have in Michigan, which is a medical durable power of attorney. There's a statute, it's in your handout, covering medical durable powers of attorney in Michigan. Michigan does not, per se, recognize living wills. You'll see that I really prepare documents for my clients, and the one I have for myself that includes the two, that functions as a medical durable power of attorney and as a living will, not only so that there's no question about what I or my clients want insofar as treatment is concerned, and it would be honored in Michigan, but I do it that way so that it would be honored in other states as well. If my client travels to Florida or Arizona or wherever the case may be, that has a living will statute rather than a durable power of attorney statute. So where can you get a good advanced directive? You can get it from the internet. The other day I searched, and I think I landed on the ask.com site, and I saw that said there were 100 million hits on that site for advanced directives. There are thousands of forums on the internet. You can get them from many organizations in Michigan, the Michigan Hospital Association, lawyer groups, community organizations, you name it. Hospitals have them. If you are going to be hospitalized, you will be asked, do you have an advanced directive? And if you don't, many hospitals will provide them to you. You can get them from a lawyer. Many lawyers do this for clients, either as a standalone document or as part of an estate plan. What do? I start by looking at the statutory requirements. Of course, if I have a document that doesn't comply with Michigan's statutory requirements, I can't be assured that a court would honor it. A court might well honor it, but I certainly want to be as safe as possible. In addition, personally, as a lawyer, I would certainly want to advise my clients as to what the statutory requirements are and to make sure that any document I give to them complies with the requirements. I also incorporate the lessons I've learned from the right to die litigation that I've had. For example, the Martin case and the slide that I showed you a moment ago. I make sure that my document and that I use for my clients is as specific as I can make it in one section. Cover everything I can think of. Conscious, unconscious, terminal, not terminal, on and on. But then I also have a provision saying that this is not to be the exclusive list to be applied by my patient advocate or a court, because I can't possibly predict every circumstance that will occur, every circumstance that I might find myself in the future where I can't express myself. Therefore, patient advocate, court, this is what I want in general, so I cover the general and specific. Ensure that it always reflects my wishes. Well, you know, my own preferences have evolved over time, so I update it. I tell my clients, you know, not only with respect to the person you select as patient advocate, but what you want or what you don't want. Those things may change over time, so let's make sure that your document changes over time. And keep it current. The statutes often change in Michigan. The statutes that I gave you were, the current ones. But for example, originally, the statute in Michigan didn't refer to hospice care. That was done by an amendment. So as soon as that amendment was made, I made sure that the document I use and the one I use for my clients made a specific reference to hospice care. That's just one of many examples I could give. So you want to make sure you're current with the law and you're current with your own wishes. Where are these statutory requirements? They're found in the Estates and Protected Individuals Code, Act 386 of 1998. The acronym for this ridiculously long statute is EPIC, as you might expect. I mean, it covers wills, trusts, administration, living, dying, advanced directives. It is an EPIC, but that's what it's called. And what I am now showing you are the principal requirements under Michigan law for an advanced directive. You have to be 18 years old or older to enter into one of them. In the Rosebush case that I had several years ago and we talked about in the first session, the Court of Appeals says, well, a mature minor might also be able to sign an advanced directive. That's in a footnote in the case, and I simply point it out here. The statute talks about individuals 18 years old or older. The Rosebush Court at least suggests that maybe there's room for some minors to be able to sign. You have to be of sound mind when you sign it. It has to be written, signed, and witnessed. Now, there's no notary requirement, but I have mine notarized. I have my clients' documents notarized because other states, many other states do have a notary requirement. So I want to be sure as I can that the document I do for my clients will be honored wherever they go. So why not have it notarized? Overkill, but that might not be a proper term for the subject. Who cannot be a witness? Well, it's interesting. In Michigan, the list is as long as your arm of people who cannot be a witness. I won't hit them all here, but it's right in the statute. A spouse, a child, a parent, a grandparent, a grandchild. None of those people can be a proper witness for your document. Your doctor, the nurse, employees of a facility where you may be residing for care. All of those people are excluded. You might wonder why, actually. I did. The legislature was so concerned about undue influence, about people being pressured into signing these things, that they added this laundry list of folks who couldn't serve as witnesses. That was the legislature's attempt to try to prevent, this undue influence from occurring. So, people can go to a lawyer's office and the lawyer has secretaries. People can go have friends sign, things like that. But you certainly can't have the folks you would typically think should be able to serve as witnesses, actually serve as witnesses. Now, the document also has to say that the advocate's authority exists only when the patient is unable to participate in medical treatment decisions. So some people ask me, if I sign an advance directive today and I name my spouse as my advocate, do I still get to make decisions for myself? And the answer is absolutely. While you are able to participate in medical treatment decisions, you are the only one who can act. Your spouse or any other person who is your patient advocate cannot act under the document if you are able to participate in those decisions. The question is whether someone who has had a history of mental issues or perhaps is under medication for a mental issue could sign a document. Well, I can't answer that in black or white. All I can say is that if the individual has signed that document at a time the individual is lucid and is not currently overcome with a mental condition that prevents that person from being of sound mind, then the document would be valid. The same is actually true of wills and trusts. I've taken care of several elderly clients, and I make sure that they are properly oriented and are competent to sign a document. I think that's my role as a lawyer. And that can vary from time to time. The question is, can one have more than one patient advocate? The answer is yes. I've had situations where my clients have insisted that each of their sons or each of their daughters serve. I'll explain that I don't, as a rule, recommend that because if you have too many people serving and they disagree among themselves, then where are you? You want to have a situation where at least one person can make a decision. But what I try to do is, in some instances, let's say my client lives in Michigan, has a daughter here in Michigan, and often travels to California where there is another child. I've sometimes put in my durable powers of attorney for those clients that if I am in California, then so-and-so is able to make a decision. If I'm in Michigan, then my daughter here makes the decision, and if I'm anywhere else, then here's who makes the decision. So I try to address it. I'm not wild about situations where 2 or 3 or 4 people are named jointly because, as you might expect, this is an area where, due to the emotional component of the decision, the religious component, different people's personal preferences, individuals simply might not agree on what's appropriate. And I don't want my clients to have to go to court to get that straightened out. So let's move on here. Now, we're talking about the EPIC statutory requirements. Now, this is not a requirement, but this is a permissive. A patient advocate designation may include a statement of the patient's desires on care, custody, and medical treatment. This is the provision that I use to make my medical durable power of attorney a living will. This is the provision that I tell my clients enables them to state whatever their wishes are. It's recognized under our statute. Now, there are some other requirements that govern when a patient advocate can actually act. The patient advocate has to sign an acceptance. And you see the language here says, which must include substantially all of the following. One provision, that the designation is not effective unless the patient is unable to participate in decisions. Remember, we talked about that a couple of minutes ago. An individual who signs an advance directive now, who's perfectly competent, makes his or her own medical decisions. The patient advocate can't make decisions while the patient is competent, and this is the statutory requirement that the advocate has to recognize that he or she can't make decisions while the patient's competent and able to act. No withdrawal of treatment decision as to pregnant patients if the withdrawal might result in her death. Well, that speaks for itself. No withdrawal of treatment to allow a patient to die absent clear and convincing authorization for the decision and acknowledgement as to possible death. You'll see in a moment the form I use says, I specifically recognize that my advocate may make withdrawal of treatment decisions which might result in my death. No compensation, but reimbursement for expenses. That's often asked. If I appoint a patient advocate, does that person get paid? No. The statute says you don't get paid, but actual out-of-pocket expenses can be reimbursed. The question is an executor the same as an advocate? No. An executor, also known as a personal representative, is the individual who acts under your last will and testament. That has nothing to do with medical durable powers of attorney. So the patient advocate acts under your medical durable power of attorney. Your administrator, executor, or personal representative acts under your will. And indeed, if you have a trust, the trustee acts under your trust. Executors and trustees can be paid, generally are paid. As a matter of fact, if in a trust, for example, you go to a bank or an investment firm, they'll charge a fee based upon the amount of the assets they manage. So they always get paid. Revocation of the designation at any time and in any manner. So again, what we're talking about is the acceptance by the patient advocate. Has to be in writing and has to say, I recognize that the patient can revoke his or her designation of me as advocate at any time or in any manner. And what's really intriguing about that provision is that the statute basically says that regardless of the competency of the patient, if the patient can express somehow a desire to revoke the instrument, that's valid. So that means, if you go back a couple of slides ago where we said that one has to be of sound mind to sign one of these documents, theoretically, you have to be of sound mind to sign one, but not necessarily of sound mind to revoke one. In the Martin case, when the Michigan Supreme Court granted leave to appeal to that court asked us specifically to address that question. Should the test for competency to sign a medical durable power of attorney be different from the test for competency to revoke one? It never did answer that question. The question, good one, this first bullet point, who decides whether the patient is able or unable to participate in medical decisions? If you look in your handout, you'll see that the requirement is that you have to have two doctors or a doctor and a psychiatrist or a psychologist. They make that decision. If there is really a dispute, you end up going to court, but most of the time, the doctor and or psychologist, two, can make that decision. The question is, what happens if two doctors are prepared to say that the patient is not of sound mind? Can the patient still revoke the document? Literally, yes. I mean, I haven't seen a case yet decided in Michigan on that point, but under the language, it would seem that that would be the case.
And choose another one. And therefore,
yeah, well, not necessarily choose another one because you might not be competent to, you wouldn't by definition be competent to sign a new document. Right. So it's an anomaly that doesn't make any sense. So in this particular provision, I indicate in my document that I want my advocate to be able to make every judgment necessary for my proper and adequate care, custody, medical, dental, and mental health treatment, and to give an informed consent or refusal on a variety of matters. Let me stop there and make a couple of points clear. We are talking about medical, dental, mental health, a whole variety of things, not just narrow medical treatment. And we're also talking about care and custody, where I should be treated, a hospital, a nursing home, whatever. The patient advocate has the right to make the decision as to all of those things. And then what do? I include as many things as I can think of. Here are some examples, including rehabilitation and dental and psychiatric, admission to hospitals and nursing homes and hospices, use of drugs, signing all authorizations and waivers, getting copies of documents, the HIPAA waivers. You know, if you go to the doctor now or you go to the drugstore under the HIPAA, these screwy HIPAA laws, you know, you have to wait in line and everything's private and they're, you know, it's very difficult to get documents. Well, I put right in mind that the patient advocate is authorized to get all documents. I don't want a healthcare facility saying HIPAA precludes me from giving you the document, I can only give it to the patient. Do not resuscitate orders. And then the most recent POLST. Throughout the country, somewhat in Michigan, but not too much yet, there are physician orders for life-sustaining treatment. I have included that in the durable power of attorney that I use. The question is, let's assume that there is a patient advocate who is an independent person, a neutral person, as the questioner premised, and puts the patient into a very expensive facility and it's wiping out the family's resources. Does the family have any recourse? The family can complain to the patient advocate, and if the family believes that the patient advocate is acting inappropriately, the family could go to court and could say, we think that what the patient advocate is doing here is wrong. At that point, the court would look at the document that appointed the patient advocate and the other circumstances and would then make a decision. I rather suspect that if the court felt that the patient advocate was acting appropriately and that the family was simply selfishly criticizing the advocate's decision, the court would probably reject the claim. But I can also understand that the patient advocate might be making decisions that are inappropriate and there would be judicial recourse for that. So what else do I put in my document? I talk about futile treatment, and I define it. I say that I define futile treatment as treatment that will provide no significant benefit to me and will only postpone my inevitable death or prolong an irreversible coma or persistent vegetative state. And I indicate elsewhere in my document that I don't want treatment that's futile once it's determined that it's by definition futile, that it's not going to do me any good. I don't want to be treated for the sake of treatment. I talked before about the acknowledgement. I acknowledge that the withdrawal or withholding of futile treatment may allow or hasten my death. There again is another indication that I believe is required under the Michigan statute in order to make the patient advocate action proper. And I also state at the end here, I want my wishes to be carried out by my advocate, even if other people disagree with me, even if family members disagree. You know, these things are emotional. Certainly the withdrawal of food and water, you know, is one of the most emotional, highly charged, symbolic issues that come up in these cases. And I want the court to know that this document is for me and is to effectuate what I want, not what other family members want. Here, the very beginning, I think we go to the question that was asked before. So I put in, if my attending physician and another physician or licensed psychologist have determined I am unable to participate in treatment decisions, then my patient advocate is authorized to do the following. So I have a whole list of things. Give or withhold consent to medical care, revoke consent that may have been given, stop treatment that might have been started or simply not started in the first place, put me in a facility or remove me from a facility. stop or withhold treatment, CPR, surgery, antibiotics, nutrition, hydration, and provide for pain medication so that I won't experience pain if I've had withdrawal, if I've had nourishment or hydration withdrawn. All of those things are perfectly valid and appropriate. This particular slide is my attempt to tell my advocate and the court that I've tried to be specific. I've talked about coma and PVS and terminal illness, but those are examples, and there are all sorts of other things that might come up where I want my advocate to act as well. And I make it clear that I'm not limiting my patient advocate. In fact, the contrary is true. I want my patient advocate to act in accordance with what I have written, in accordance with what I have stated are my wishes, whether or not I've described each and every one of them. I can't predict the exact medical condition, so even if I'm in a condition that I haven't described, advocate, still act. I don't want to be maintained with ventilators and feeding tubes and other medical equipment if I'm catastrophically injured or hopelessly ill with no significant chance for recovery, et cetera, if I can't perform basic human functions. This is the Michael Martin test in my view. That was his condition, and I don't want the Michigan Supreme Court to say that I haven't been specific enough. The question is, well, wasn't the Martin case, didn't it turn on the fact that Michael wasn't specific enough? Absolutely. So what I'm trying to do is be as specific as I can, but then also say that I recognize that there are other situations that might arise. I might be conscious, I might be unconscious, I might be terminal, I might not be terminal, I may be in pain, I may not be in pain. I want my advocate to be able to act. Now remember, Michael Martin didn't have a medical durable power of attorney. I don't know for sure what the court would have done if he had had one. He wasn't the type of person to put his wishes in writing, and his accident was 4 years before our medical durable power of attorney statute in Michigan. So, you know, my expectation is that if my document ever were before the Michigan Supreme Court, the court would say, you know, this individual has not only been specific, but he's also been very general. He's told us what his philosophy is in all sorts of situations, and under the law, we will permit his duly appointed patient advocate under the statute to make any decision for him. He couldn't have done more. The question is, how do you prepare for, you know, what should be in your document? And given the fact that technology evolves over time, there are advances, and we don't know what the situation will be years from now, the best I can say for you is this. Number one, you prepare a document now that states your current wishes. You talk to somebody, whether it's a lawyer or you read your statute or whatever, and you say, these are the things I know I have to address, and then you address as many things as you possibly can think of. And then you make it as general as you're comfortable making it. And then you sign it, and then you periodically review it. So if you're in a situation where 5 years from now, you know there have been some additional technological advances that maybe have caused you to rethink what you've written in your document, change your document. This document is not carved in stone. It should be updated frequently. There is no statutory requirement that it be updated every, you know, year or something like that, but it ought to be updated as your thinking changes, as your circumstances change, and as the environment in which we exist changes. So as medical care and technology evolve, if those things change your thinking in one direction or the other, update your document. The question is, what happens if a patient advocate doesn't want to make the decision, is stressed out, has family members pressuring him, says, I want out? The patient advocate always has the right to resign. There is no requirement that the patient advocate serve. There's no contract that requires him to serve, or if he resigns, he's liable for damages. And that's why it's always a good reason to have a successor advocate named. And that's also why it's important to talk with your patient advocate while you can about your wishes, so you know that that patient advocate is prepared to make a decision and is prepared to make a decision that is consistent with your own wishes. This slide says, you know, I value my autonomy. I don't want others to take it away from me or to say that I've changed my mind. Now, obviously, if I'm in a situation down the road where I'm incompetent, I'm by definition not able to participate in treatment decisions, and somebody comes in and says, look, he's revoked his patient advocate designation and he wants to live. I don't know exactly how to prevent that other than to say, hey, I'm aware that that's argued in many instances. Actually, that happens in every right to die case. It happened in the Martin case. The other side opposing us said, look, Michael is smiling, he's happy, he must be deemed to have revoked his, changed his mind, not revoked his designation, he didn't have one, but changed his mind about life-sustaining treatment. We had doctors testify in court that no, he was smiling because he has these massive brain injuries and can't do anything other than smile. And the court ultimately determined he hadn't changed his mind. But this kind of thing comes up, so I throw it in my document too, saying, Judge, I don't want anybody to come in and say I've changed my mind because I want you to respect what my mind is now. I say that I regard the delivery of food and water through a feeding tube or other means as medical treatment, and it can be rejected or withdrawn regardless of how other people view that decision. And then finally, in my document, I say that I want my document to be regarded as a living will in other states and as a medical durable power of attorney here so that it's portable. I don't say that this is necessary language, but you know, nevertheless, I'm expressing this in the document so that hopefully if I go somewhere, you know, to another state and have a problem, a medical problem or emergency there, my document would be honored. So, witness statement. You can see here, I mean, there's a witness requirement, and I have it witnessed. I also throw in the notary, and I have the witnesses say, I'm not a parent, I'm not a child, I'm not a presumptive heir, I'm not this, that, and the other thing. All those things that the statute excludes. And then I have an acceptance, and I'm not going to go through this acceptance very long because we're running to the end and I want to allow some more questions. But as I showed you before, the form says there has to be an acceptance. It has to include certain things. So I accept it. I recognize that I can't act for John Smith unless he's unable to participate in decisions. I recognize that I can't make a decision to withhold or withdraw treatment from a pregnant person, that if that would result in the pregnant person's death, that I can only withhold or withdraw treatment that would allow John Smith to die if he's expressed to me in a clear and convincing way that I have the authority to do that and he recognizes that's what might happen, and I won't receive compensation. And finally, that he can revoke his designation at any time and in any manner. So what I've done is I've just gone through the statute and I've put in the document every darn statutory requirement so there's no question, witness, and that's it. So, general questions. The question is, well, what about hospice? If it's not in your document, you have to amend your document. No, you don't have to amend your document. I mean, the fact that the statute permits an advocate to make hospice decisions doesn't absolutely mean you have to include it in your document. I simply choose to include it so there's no question. But if you had a document that didn't refer to hospice care, Could your advocate still do a hospice placement? Absolutely. What's the difference between a living will and a medical durable power of attorney? A living will is simply a document in which you express your desires. This is what I want. I want CPR, I don't want CPR, I want this, I want that. A living will does not appoint someone to make decisions for you. It simply is an expression of what you want. In contrast, a medical durable power of attorney is a document in which you are appointing someone, an agent, a patient advocate, to act for you. As I said before, I throw into my medical durable power of attorney living will statements, statements about what I want and don't want. So the document I end up with is really a composite of the two, even though they are actually two separate and distinct concepts. What's the purpose of the pregnancy provision? Well, the legislature decided that withdrawal of treatment decisions from pregnant women, if such a decision could result in the pregnant patient's death, aren't something that the legislature was comfortable statutorily recognizing. I think one would probably have to go to court. And there are court cases all around the country, from time to time involving whether a pregnant woman can, forego treatment and what will the effect on the fetus be and all of that. The Michigan legislature simply wasn't willing to address that issue as part of the medical durable power of attorney statute. What happens if you're traveling out of state and there's a medical problem, an illness or an injury? Will your document be honored? I would say yes. Many states have provisions, Michigan doesn't, but other states have provisions indicating that documents that are valid in other states will be honored, sort of a reciprocity concept. The fact is, as I said before, I try to make my document sufficient with the notarization too, so that it would pass muster in any other state. And when all is said and done, courts really ought to be looking at, whether they're in Michigan or elsewhere, what does the patient want? What does the patient not want? If you have a document that clearly addresses that, it ought to be honored anywhere. The question is, how often do disputes really arise? Not all that often. Certainly they don't arise in court all that often. Thank goodness they don't belong in court. But they'll arise fairly regularly, where one family member wants one thing and another wants something else. And if there's a patient advocate designation and there is a single advocate who has authority, that ought to put the end to the controversy. That's really the whole subject of the final presentation. When do disputes arise and how are they resolved then? But ideally, if we have advanced directives, if we communicate with family members and doctors about what we want and don't want, there shouldn't be disputes. But are there from time to time? Sure, absolutely.